Good morning. We're going on the record. State of Arizona versus Lane Jeffrey Myers, CR 24013770. Record reflect the presence of Ms. Samantha Walker in person on behalf of the state. Present the defendant also in person out of custody, seated at the defense table. This is the time set for a status conference, but first we need to do a formal arraignment. So, sir, if you could confirm we have your full correct legal name.
Yes,
first
sir.
name Lane, middle name Jeffrey, last name Myers, M-Y-E-R-S. Is that correct?
Yes, sir.
If you could confirm your date of birth.
October 15th, 1982.
And an address at which you received mail. Thank you. That's a house, no unit or apartment number?
House.
All right, we also have then an email address of
And I will put for the record that I do appreciate, so yesterday somebody tried to call me to tell me how I got switched, and they kept saying, wait, they wanted me to wait on the phone until the email went through, but it never came through. As of right now, I never got the emails. She said she sent it 3 times, but as we stand here, I mean, I knew it was gonna be a quick turnaround because I wanted that, so I came here in person and got this. But the email from the clerk or whatever that you said in here, it never came. As of right now, it still hasn't came, and they said they sent it 3 times. Confirm the email and all that. And I get other emails from other cases.
All right, thanks for letting us know. We'll look into that on our end. And then, sir, have you ever served in the U.S. Armed Forces?
No, sir.
All right, next, I must inform you, the state of Arizona has charged you with a violation of the law. Specifically, they've alleged you violated Arizona Revised Statute Title 13, Section 2810, subsection A2. That's interfering with judicial proceedings, failure to comply with the court order. It's a class 1 misdemeanor, maximum possible penalty, $2,500 fine, plus additional surcharges up to 6 months in jail, 3 years probation. I don't know if the state will seek the maximum penalty. That is the maximum allowed by law. Because you've been charged with that class 1 misdemeanor, you'd have to receive prior permission from the court before you leave the state of Arizona. But before we go any further, I do want to review some of your constitutional rights, okay?
Please do, because they're important.
And so you have the right to plead not guilty, and I'll enter a not guilty plea on your behalf at this time.
Thank you.
You also have the right to a trial, and you have the right to the assistance of an attorney at all court proceedings. You further have the right to remain silent, and you are currently presumed to be innocent, unless or until the state can prove your guilt beyond a reasonable doubt. And even then, even if found guilty at trial, you would still have a right to an appeal. However, you would lose that right to an appeal if you were to cause your own sentencing to be delayed more than 90 days past any conviction. Now, you further have the right and the responsibility to be present for all future court proceedings. You fail to appear for any court hearing, a couple things could happen. First is that the proceeding could be held in your absence, including even the trial. Second thing that could happen is that a warrant would issue for your arrest. You'd be charged warrant fees. Could be charged with another misdemeanor offense called failure to appear. So it is your responsibility to keep your current address and contact info updated with the court. That's how we'll let you know what's going on in your case and when your next court date is. So as I indicated, you do have a right to an attorney. In some cases, you'd have the right for the court to appoint you one, but only if the state is seeking to deprive you of your liberty.
Right.
So this time I'm going to ask the state prosecutor. Ms. Walker, the state seeking jail or supervised probation in this matter?
Yes, Your Honor.
It is?
Yes, Your Honor.
All right. And so, sir, again, I noticed you had filed the notice of appearance that you would like to proceed pro se. Of course, since the state is seeking to potentially deprive you of your liberty, you are entitled to.
They've already done that, actually,
So,
by charging me.
right, so again, that would.
I drove past will I be arrested on my way out because I drove past 30 feet past the law school down Speedway today? We need to get to the constitutional issue of these charges. We can't even arraign me without probable cause.
Your Honor, I would implore you to.
I would implore her to not interrupt.
Again,
Is she objecting or is she talking over me?
Yeah, so we can't have people talking over each other because we are recording.
It's my
everything.
turn to talk.
Right, and so then Mr.
So I
Myers,
drove
you
past
have
30 feet on the way there, and I'm gonna drive past 60 feet on the way home. Will I be charged, yes or no?
So, Mr. Myers.
I'm charged with being 150 feet from a protected location in a moving vehicle. So will I be charged on the way home because I drove past on the way here and home? I'm gonna drive past the same location that you're arraigning me for and make a mockery of this whole fucking thing.
Right, and so Mr. Myers, one, will not use profanity in the court. We will maintain judicial decorum in the courthouse. The second thing is, as a judicial officer, I cannot provide you legal advice. Third thing is, I don't know what the facts of the case are. I need to remain.
We're gonna have an evidentiary hearing next week. Please set one.
All right, so Mr. Myers, again, I don't have any requests in front of me.
Okay, I'll put one in. I'm requesting one verbally, verbal motion.
And so, Mr. Myers, just as I gave you a turn to talk.
Right.
You
Go ahead.
will not speak over the court because, again, we are recording everything. All right, so like I said, I can't provide you legal advice. I don't know what the facts of the case are. So I have formally arraigned you here in the matter. Again, the state was seeking to deprive you of your liberty. You are entitled to an attorney as a matter of right. However, I noticed you filed the notice of appearance saying you'd like to proceed pro se. I just want to make a clear record. You would not like the court to appoint you any counsel.
I don't need a kangaroo. I don't need one of your fake kangaroo attorneys, no.
Right, and so again, Mr. Myers, if we can maintain decorum in the courtroom.
Like you said, you had 9 years experience when you had 3. My wife actually trained you.
Okay, I don't what you're referring to, Mr. Myers, but again, we're going to maintain decorum here in the courtroom. So I am your assigned judge. Our next court date, we already set for that status conference on December 5th. Mr. Myers, any other questions or concerns?
Oh yeah, big time.
Here today?
For sure. I want to move the motion to compel production as of November 5th. So they like to play games. We have another case 5 months in. They still haven't turned over the evidence. I'm going to tell you right now, Your Honor, I'll file a motion to compel under 15-7 every single day in this case. Because I can tell you right now, the police officers have the police reports. I don't have them, okay? A local reporter went and got the police reports, but I don't have them. I've put in a request for them. I've put in requests for pretrial interviews. I haven't even got a response. Nothing. They didn't properly serve me. Her motions don't meet the rules under 1.6. They're supposed to be 12. 13 font, they're 12. They're not formatted properly. Her headlines aren't underlined. They're not italicized. She doesn't even know how to format a motion. The motion that came in the mail, you should have stricken it because it didn't meet 1.6 or 1.9. It wasn't formatted properly. So then the next one that came, you know, I don't want to nitpick because you actually granted it, but if she can't put the proper font, she can't file the motions. That's like literally Arizona Rule of Criminal Procedure 1.6b. So the issue now we move to is disclosure. We're sitting here when I know for a fact under Rule 15.1, they're required to turn this over, but they've been dragging their feet because as of on November 5th, a local reporter got all this case information, but I put in a request on October 25th. So the defendant in the case requested it on October 25th, still doesn't have it, but a local reporter requested it on November 5th and got it the same day. But I don't have it.
So again, Mr. Myers, I don't know what you're talking about because I don't have any written form.
I did put it in
front of me.
I did put a request for disclosure in. And I gave it to her and it was properly served.
Right,
And you don't have to do
understand that
certificate of service in a
there's
lower
requests.
court.
Right.
You know, and I told her how to serve me. And they sent me an envelope in the mail with their motion and the minute order from your order. That's not how we're doing service in the court, okay? They have my email. We have another case going on. They're seeking jail time because I booed at City Hall, not because of this. This is a mockery, sir.
Jail time on that case.
Huh?
I'm not seeking jail time on that case. Please don't mistake the facts.
No, you're seeking it in this case to get it out of that, to try to cover up what you're doing in that case. You're a clown, plain and simple. Are we done here? So you want motion to compels? Because I know judges hate motion to compels. Because I'm gonna file one every day. Where's the disclosure? It's been, so.
Again, Mr. Myers, you've asked a litany of questions here.
I gotta talk fast before I get arrested.
Your Honor, may I be heard?
Yes, Ms. Walker?
Thank you, Your Honor. The first thing that I would like to address is to inquire if Mr. Myers is live streaming, broadcasting, or recording this hearing, as well as any of the multiple observers who are online. The reason that I ask this is because Mr. Myers has historically recorded without permission, as well as broadcast information without the court's permission.
Objection, Your Honor, irrelevant. I got permission. This is the gaslighting that they want me to get me pissed off and arrested at for today.
Your Honor?
So, Ms. Myers,
She doesn't even know the rule. 122H,
Mr. Myers.
broadcast is not coverage.
Right, again, Mr. Myers.
Just tell her to be quiet then.
We'll maintain decorum again.
I just dealt with this yesterday with the same thing in a different hearing yesterday with this
Your
bullshit
Honor,
with her.
at this point, I would ask that you hold Mr. Lane Myers in contempt for failing
Myers.
to obey the court's orders.
Again, I'm going to remind you, we're not to use profanity here in the courtroom.
Actually, it's my First Amendment right to use profanity. I get what you're saying though. I'll be decorum. Like I won't. We can find a line between me using the words and the words you don't find acceptable, and what I might want to say that isn't traditionally what's said. I don't need to use every profanity, but if I drop one once in a while, that's just who I am. Hold my disability against me, I guess.
So again, Mr. Myers, there's been no filing of any ADA accommodation.
No, I'm
requests.
going by what they say. They say I'm disabled. I'm not.
Right, and so again.
I'm crazy, I'm disabled, I'm mental, I'm a domestic terrorist.
Right, I
They
don't
got a
know.
wanted poster for me. So let her tell her thing how I can't record under a Supreme Court rule because it hurts her feelings while other people are doing it. While the whole case, look at Shannon Walker, a victim, is doing it, right? She's allowed to watch, but why can't other people?
Your Honor, if I may be
So
heard.
the record will reflect the presence of the victim appearing remotely.
There's no victim in this case. There's a victim, there's no victim. So that's what I'm saying. Why does it say victim? This was a civil injunction that's a plaintiff and a defendant.
Right, so Mr.
So
Myers.
in this case, when you violate the court order, there's no victim. I didn't talk to her. I violated it by driving past the building. There is no victim in this case.
Right, again, Mr. Myers, I don't know what the facts of this case are.
Why does it say victim?
I'm going to turn to Ms. Walker for some clarification. Ms. Walker.
Thank you, Your Honor. This is, Mr. Myers has been charged with interfering with judicial proceedings, failure to abide by a court order. The alleged victim is Shannon Walker, the holder of that court order, the injunction against harassment. We won't go into the facts of the case, as this is
Oh,
not
we'll go into
either an
Mr.
evidentiary
Myers.
hearing nor a bench trial. I would also like to revisit Rule 122.
H.
I would also, Your Honor,
Right,
I
Mr.
would ask
Myers,
that you not interrupt
just
me.
as we gave you the opportunity to speak, we're now going to give Ms. Walker the opportunity. So
Is
Ms.
my
Walker-
presence required here still?
Yes.
Yes, it is, Mr. Myers.
For what?
Because we're in the middle of a legal
Alright,
proceeding.
Alright.
Ms. Walker.
Thank you. Your Honor, under Supreme Court Rule 122, a person must request to record or broadcast.
Except as
Mr.
provided
Myers,
in subsection
Mr.
H.
Myers,
Mr.
This is
Myers.
wasting our time.
Mr. Myers, your interruption, again, is interfering with a legal proceeding. Ms. Walker, please continue.
Thank you, Your Honor. Under 122H, as Mr. Myers states, it does authorize the use of a personal audio recorder. First, he must put in a notice of using that personal audio recorder. None of that has been used.
Actually, I did. You're wrong. I did it before you got here. So you're fucking gaslighting us.
Mr. Myers, Mr. Myers, please do not use profanity in the courtroom. And also, the parties are directed to speak to the court, not to each other. So, Ms. Walker, Mr. Myers is correct. He did provide notice that he is recording with a personal device pursuant to Supreme Court Rule 122, subsection H.
Thank you. The rule that I would clarify then, Your Honor, is he recording? And I would just like to clarify that. And also, any observers must also put in that notice or a request. None of those are present here, so I would implore the court to ask the gallery if any of them are recording.
Shannon Walker, the victim, that's the gallery.
Right, so again, Mr. Myers, we can't just speak whenever we want here in the court proceeding. So I will note that Ms. Walker is correct. There has been no request to record the broadcast, to record the court proceedings. So I want to remind all those observing that you are not to be recording these proceedings. It would be in violation of the Supreme Court rules. So anything further at this time, Ms. Walker?
Yes, Your Honor, I'd like to address, I do have initial disclosure here with me. We've also put in a request for media. All of that will be making its way over to Mr. Myers. We do have his email. We will be sending that shortly. If you would like to ask for any kind of evidentiary hearing, I would ask that substantive motions be filed, as is required, so that I may respond to them. So at this time, that was just me clarifying the record. I would also just ask in the future, I understand the urgency of needing to set this hearing, but there is a victim in the case. She's been watching me very closely, and that's how she caught that there's the hearing today. I actually didn't even know that this got set today.
She could have requested.
So again, Mr. Myers, I'll give you another opportunity to speak. Right now, it's Ms. Walker's turn. Thank you.
So just moving forward, I would request, I'd also like to confirm that Mr. Myers is not live streaming. That is a major concern with this case, and that he is in fact just using a recording app rather than any kind of phone or live stream.
Read 122H, sir. It says broadcast on person. It defines in 122H cover and coverage. We can play games. I'm not stopping.
Your Honor, that seems to give me the impression that he is in fact live streaming or broadcasting this, and
Broadcasting under 122H,
Right, again,
audio only.
Right, again,
So are
I'll
you.
allow you an opportunity
Right, so are you. You're broadcasting under 122H also.
Your Honor, if I may just clarify, and I do have the rule with me.
Me too, in my head.
A person may use a personal audio recorder during a proceeding, but the person must notify the judge and the judge's staff prior to using the device.
I did.
A person, and actually that does have a timeline, Your Honor, of I believe it's 2 days.
No, it doesn't. You can literally do it when you walk in the courtroom.
Mr. Myers, again,
And-
I'll allow you a proper opportunity to respond, but we cannot interrupt.
And
Walker.
a person who uses a personal audio recorder is not required to submit a request under paragraph C of this rule, but a person who wishes to record or broadcast the audio portion of the proceeding with the device that is not on the person must do so. The use of a personal audio recorder must not be obtrusive, distracting, or otherwise prohibited, and use is subject to prohibitions of paragraph K of this rule. Your Honor, this case is, as you might already tell, a rather high media case given Mr. Myers' online following. This case in particular regards an injunction against harassment given his streaming, as well as any other context that he has
Allegedly.
with Ms. Walker, Ms. Shannon Walker, the victim. So for these reasons, I would implore the court to not permit any kind of broadcast. And I would again ask if he is in fact live streaming and broadcasting this proceeding.
Thank you, Ms. Walker. Mr. Myers, if you wouldn't mind from the microphone so we can pick you up on the recording.
122H, let's read it again. It says, if you're doing it not on your person, which means if it's on your person, you do not need a request. broadcast is defined in the definitions on 122. Since you got the rule in your hand, why don't you stop gaslighting the American people and start at the top under definitions, cover and coverage. You're right. Cover and coverage, Your Honor. Cover and coverage. It's in the definitions. Cover and coverage apply to C, D, E, F, G, not H. Alphabet is hard. A, B, C, D, E, F, G, H. H specifically says that there is no 2-day timeline. That's for coverage. You cannot object to this. People can walk in and say, Your Honor, I'm recording. Set it down. It's on my person. I can broadcast because the word broadcast and the word cover and coverage are defined in the Supreme Court order, so we avoid stupid-ass conversations like this.
Mr. Myers, again, and we raise our voice. Why?
Because she doesn't hear well.
Right, but again, you're addressing the court.
You're right.
And so
I apologize, sir. I apologize.
Thank you.
The idea is, it's not super splurge, okay? Surplusage heart. Supreme Court, she wants you to overrule the Supreme Court right now. You can't do it, and I'm not stopping.
Right, and again, nobody's asking you to, Mr. Myers.
Thank you.
Thank you.
Your Honor, I would just like to be heard on one final thing.
Certainly.
A personal audio recorder, and when this rule was generated, it's defined as a device used to record audio only, and that is on, held by, or immediately next to the person who's operating the device. If the device is able to also broadcast the audio,
Go down.
Therefore, it is not a personal audio recorder and should not be permitted in court.
Then why does it use the word broadcast in H if you can't broadcast in H? Why is the word broadcast in H? And furthermore, she just gaslit us again because if you go 2 definitions below, you notice I'm not even using no papers like her. Go 2 below. The one she just cited, personal audio recorder. Skip 1, go to the next one. Recording device. What's the last words in recording device? Cell phones and personal audio recorders are considered recording devices. So she's picking and choosing which definition she wants to put on the record when you can see right with your own 2 eyes, sir. There's personal audio recorder, there's another definition, and then there's recording device. And what does it say?
Only refers to personal.
And then H says broadcast. Well, how could you broadcast if it couldn't broadcast?
So, Mr. Myers, in fact, we're all going to read H here together.
Thank you, so she can understand it.
Mr. Myers, so personal audio recorders require notice to the court. A person may use a personal audio recorder during a proceeding, but the person must notify the judge or judge's staff prior to using the device, which you've done. A person who uses a personal audio recorder is not required to submit a request under paragraph C of this rule, but a person who wishes to record or broadcast the audio portion of a proceeding with a device.
That is not on the person. That is not on the person. That means setting up my fucking thing over here in the corner or blocking. You can't be obtrusive. You can't have cords all fucking, they're all tripping over.
Again with the profanity.
But I'm saying, you're gaslighting us. The hearing's already over. I already recorded it. It's already been broad streamed, and so have hundreds of other people.
Mr. Myers,
it's not going to stop.
I'm attempting to read the rule.
I don't need to know the rule. I know the rule. That's why I came in here, notified her, and I'm following it. It's on my person.
Right. And Mr. Myers, it seems like I'm not reading the rule for your benefit, but again for the record, as well as for Ms. Walker.
Thank you.
And so, can we
Thank
please
you.
not interrupt
Thank
the
you.
court?
Thank you.
But a person who wishes to record or broadcast the audio portion of a proceeding with a device that is not on the person must do so. Of course, now at this point, Mr. Myers, I don't see the device on your person.
I'm putting myself in timeout so I don't keep cussing at you because this is turning into a kangaroo court, and I had more respect for you before I walked in here.
Right, and so, Mr. Myers, I don't know why you think it's a kangaroo court.
I'm saying it's not. I don't want it to be.
Right.
Because we're arguing over something that, why do I keep having to come in these hearings and tell them how the Supreme Court rule works? What is she afraid of?
Mr. Myers, this is
the truth?
Mr. Myers, this is the first court hearing in this proceeding. I don't know what's
But she's
going on.
bringing it, she's talking about other cases, saying it's a big media case. Well, maybe you shouldn't have arrested me for booing at the city council meeting and it wouldn't be a big media.
Again, Mr. Myers, I don't know what's going on in your other legal proceedings.
Well, she wants you to know. She wants you to know that all this attention is because I'm making videos about her because of other cases. Now I got all these people that want to know what's happening to me, and now they're making videos of her, making fun of her, and I put her picture on a t-shirt making fun of her, and so now she doesn't think that 122H should apply to me.
Mr. Myers, I'm not aware of any of those facts. And again,
Oh, I'm sure she's going to follow that motion like she did in the other case. I'm sure you're going to get a Rule 11. I'm sure you're going to get all that. I'm going to follow Rule 11 on her, actually.
Mr. Myers, that would be a not, again, a legally non-cognizable filing.
This whole proceeding is a joke to me.
Your Honor, I think at this point.
Because what happens when the injunction gets thrown out? Because I'm appealing the injunction. So if the injunction gets thrown out, how did I violate it?
It was held out yesterday.
That's irrelevant. See, she just brought that in there. That's prejudicial to the proceedings. That needs to be stricken from the record because it's allegedly, I still have my, didn't you just read here that even when convicted, I still have an appeal, right? So she just said it was upheld yesterday, but how does she know that it was lawfully upheld until I challenge it upon appeal? Now, if she wants to say it was upheld upon appeal, sure, but she just prejudiced the jury. You're also the jury, sir. So unlike a normal jury trial, the jury wouldn't get to hear all this back and forth nonsense. They would just come in here with a fresh slate. So if she wants to throw slang dirt on it, that's allegedly, it needs to be stricken from the record.
Okay, Mr. Myers, I don't know what the facts are of this case, but of course, there is an order issued from the court. That would be a valid court order.
Oh, I'm not going to break it. Yeah, I mean, I take that serious, but I don't, this whole stopping me from recording when the rule, what are we here arguing about a Supreme Court rule for? This happens, there's people watching this right now, watching this kangaroo turn into this thing about this 120. Every time I come into these hearings, I had to argue for 10 minutes yesterday about 122H. Why?
Mr. Myers, this is now the second time you called it a kangaroo.
No, I said I don't want it to turn into.
Again, everybody is recording this. We can go back and listen.
I hope they are.
Okay.
Because they're going to see that this is all she's worried about is the coverage of it. Let's talk about the facts. We can't talk about, can I please leave, sir? I just want to go home and go back and mind my own business.
Any further before we come back then for the next status conference on December 5th at 8?
You're going to keep that one on the 5th? I think I have another, we might have trial that day actually in a different case.
We have trial on the second.
It might go a couple days.
Again,
It will
the
not.
court just...
How could she say that it's not going to go a couple days? Is she the judge in the case?
The judge has
Mr.
only
Myers,
stated
I'm
it
not
for
sure
a
why
day.
you're raising your voice at me again.
Is it time for me to leave?
The court is reaffirming the status conference on December 5th at 8:45 in the morning. Any questions or
Can I,
concerns?
so I'm going to file Rule 16 motion to dismiss before then. She's saying she wants me, I'm going to put the Rule 16 suppression motion in too, so you can set an evidentiary hearing.
The court has those properly before it on December 5th. We can address those at that.
So what you're saying, no, because they won't have 10 days to respond. And then they'll complain that I didn't, it's a game. I take your order serious. When I say it's a game, that doesn't mean I don't respect what you're saying. I'm saying this is
Mr. Myers, any other questions or concerns
No.
before we adjourn?
No.
Ms. Walker, anything further?
what time on the 5th?
One moment.
No, Your Honor, I would just make a note that we have sent out initial disclosure to his email, and you also have what I have on my person.
So why haven't I gotten it before today?
Again, Mr. Myers, letting Ms. Walker speak right now. Ms. Walker.
Just clarifying that for the record. Otherwise, no, Your Honor, I have nothing further.
All right, Ms. Myers, anything based on that?
Well, I'll be ready at the status. Hey, I'm not going to come into the status conference the same.
Your Honor, I would ask that he be required in person.
Oh, I didn't say I wasn't going to come there. I'm saying with the same attitude. See, look at. Am I good?
There being nothing further, then we are adjourned. If you'd like to wait for a copy of the court order for here today, you can, then you're free to leave.
I'm going to be 122H at every hearing. So we're not going to keep having this hearing, this argument every time, sir. So make sure we understand that I'm going to put the same thing in.
We're off the record.
Thank you.
Thank you.
We're not going to have the same discussion at every hearing, wasting my time.
Ms. Myers, we will maintain decorum next time.
Yeah, that's what I'm saying. I got it. Do I need to sign or something?
No, you're all set.
Thank you, Your Honor.
Have a good day.
You've reached Deputy County Attorney Samantha Walker, Misdemeanor Supervisor. Please leave your name, case number, and a brief message, and I will return your call as soon as I am able. If you are defense counsel, please consider emailing me, as I might be able to answer you sooner. If you do not leave your case number and your name, I cannot return your call. Thank you and have a great day.
Please leave a message at the tone. When finished, you may hang up or press pound for additional options.
Hey, Samantha. My name is Joey Payne, and really, I'm just calling to redress some grievances. Now, I don't know how many words past grievances you'll actually listen, so I just want to impress that redressing grievances is a constitutionally protected right. So that's what we're doing here today. Is I'm making sure that you understand that you swore an oath to protect a certain thing, and this is part of that thing. You signed up for the public scrutiny, and we're here to give it to you. So we're going to start with the fact that you don't understand that the public is allowed to have grievances, and when they're pissed off at you, they're going to take them up with you. I read one of your poorly written motions, the one we're talking about right now, where you were talking about the grievances, and it seemed like a schizophrenic might have wrote it. Are you taking any meds, or do you need a wellness check of some sort? And then your font, it was 12-point font. You should know at this point that it's 13-point font that's acceptable. I don't know why you don't get that, but 13 points. You got right with the double spacing, but there were no underlined headers, nothing like that. I don't know how old you are, but do you remember? Are you old enough to remember like Cracker Jack boxes? I wonder if they gave out your law degree in a Cracker Jack box, because it seems like you're awfully incompetent at your job. But anyway, I wish you'd stop pursuing this malicious prosecution against Lane for booing while other people were clapping. Boo! Boo, Samantha Walker! Boo! 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 Boo, Samantha! Boo! Boo! You want to give me a call back? It's 602-932-1110. Do the right thing, you dirty, nasty bitch.